back in Legal System Lectures, Part 5, Litigation. Civil cases are lawsuits where one party is suing another party. To prevail or win in a civil lawsuit, the plaintiff has to demonstrate that their claim is more probable than not, or more or less like 51% right. Parties to civil lawsuits have procedural rights of due process, the right to have their case tried fairly without bias or discrimination. Due process of law is a right guaranteed by the U.S. and state constitutions. Due process can be secured by compliance with the rules of civil procedure, which are court rules aimed at establishing a level playing field for all parties in a civil action. A person who loses a civil lawsuit may be ordered to pay compensatory or punitive damages. Compensatory damages compensate for harm done or losses created. Punitive damages punish the offender to make sure that they think twice before doing it again. People who lose a civil lawsuit may also be ordered to comply with an injunction, which is a court order to either do something or stop doing something, such as stop polluting, stop discriminatory hiring practices, or put up a fence to, for example, to screen a junkyard. Criminal cases are charges brought by the government against an individual. The titles of a criminal case is usually state or people of the state or United States of America versus the person's last name. In order to convict a criminal defendant, the prosecutor must prove the case against the defendant beyond a reasonable doubt, which is something more like a 99.9% certainty. The difference in the burden of proof, or the difference between the legal standard between a civil case and a criminal case, is why someone might be found not guilty in a criminal case but then be found liable in a civil case on the same subject matter. A good example of this being O.J. Simpson, who was found not guilty of the murder of Nicole Brown Simpson, but then when the family sued for wrongful death as a civil suit, he was in fact found liable. Defendants in criminal cases in the U.S. have substantial rights regarding process under the U.S. and state constitutions. Many of these aren't the case in other countries, such as the right to remain silent. In the Italian legal system, for example, and many others, you have a legal duty to participate in the investigation of your case by police, whereas in the U.S., you do not have to speak with them at all. You have other rights like the right to subpoena witnesses and to have a speedy trial. Criminal cases also have court rules of procedure called the Rules of Criminal Procedure. And if convicted, a criminal defendant may receive fines, orders to pay restitution, a jail sentence, which is an incarceration sentence. They could have a incarceration sentence that is suspended so that they're subject to probation, which may have certain requirements, such as attending drug and alcohol counseling. And in some criminal cases, the defendant may be executed, that is, put to death. Civil cases start when the plaintiff files a complaint. The respondent or civil defendant files an answer to the complaint. So those are the names of the first two pleadings or official filings in the civil litigation process, a complaint and an answer. This is just the first 2 pages of a federal complaint that I filed on behalf of a citizens organization I represent in Burlington. It is a federal complaint in the U.S. District Court for the District of Vermont regarding an environmental or National Environmental Policy Act case. Criminal cases start with a charge or indictment, and it may be called different things in different states. The defendant may be arrested or simply issued a citation or order that looks like a ticket to come to court on a certain date. What I've put up there as a picture is in fact a a ticket, Vermont Fish and Game ticket or citation, to come into court to answer to some fish and game charges. This was a client of mine, Mr. Tarbell. We did get this case dismissed, so he was in fact not guilty of these charges. The citation is, however, part of a public record. The prosecutor then decides whether the person should be charged. So the police don't actually do the charge. They issue you a citation or arrest you, but then they refer the case to a prosecutor. Federally, that's called a U.S. attorney. In Vermont, the prosecutor is called a state's attorney. In other states, it may be called a district attorney. And the prosecutor decides whether or not the person should be charged. The criminal court process formally starts at an arraignment, where the charge is read to the defendant, and the defendant puts in an initial plea of guilty or not guilty. The next step in the litigation process is discovery. That's where you get to ask questions of the other side about their case. Types of discovery include written questions, called interrogatories, oral questions that are answered in person under oath with a court reporter taking a transcription of the conversation. Those are called depositions. You can also submit document requests. Different jurisdictions set limits on discovery, including how many questions can be asked or how long a deposition can last. Discovery can be very expensive and time-consuming. Because of a criminal defendant's right against self-incrimination, the prosecution can't depose or ask interrogatories to a criminal defendant, although they usually can ask questions of defense witnesses, and especially expert witnesses like fingerprint or DNA experts. States vary and jurisdictions vary as to how much information the prosecution has to give to the criminal defendant as well. In federal court, the defendant gets almost no information from the government. In Vermont state court, pretty much the entire police file is available to the defendant. Provided just a quick little snippet out of some requests for document requests that I submitted on behalf of my client, the town of Holland, in a recent administrative trial. The next thing that happens in the litigation process would be motions. So I listed some common motions in criminal cases and civil cases there. And motions are requests to the judge for formal rulings on different areas of the law before a trial. And often they're motions to do away with a trial, like to dismiss the case or to grant summary judgment, that is judgment without a trial in a civil case. That, getting back to Mr. Tarbell's case, is just a quick motion to exclude evidence and dismiss the case that I filed on his behalf. And again, this case was successful from the defense perspective, and we did get this case dismissed. The vast majority, by which I mean well in the 90%, of both civil and criminal cases are settled through a settlement agreement in a civil case or a plea agreement in a criminal case, where the defendant pleads guilty either to the original charge or to a reduced charge or an agreement for a particular sentence. In which case, once the case is settled or reached a plea agreement, it does not go to trial. Some cases are resolved by the parties themselves in negotiation or mediation, and we'll discuss alternative dispute resolution like mediation in another PowerPoint lecture. If, however, the case can't settle, then it goes to trial.